Okay, so class, we have come to the final topic for the semester, which is damages for breach of contract. I know you also learn damages under Tort Law, okay, but the topic is made as the first topic, okay, for the semester. So, but for law of contracts, so we make it, we make the topic, the same topic, damages, but we make it towards the end or the final topic, okay, for the semester, or even for the syllabus, okay, because now you are doing your contract too. Okay, let's see what I have. Actually, in terms of number, we have around 90 slides okay, to finish. That's why I don't think we can finish within 2 physical classes. That's why we have the online class today. But it's only 40 minutes. So hopefully it won't be too burdensome because it's already late in the afternoon and you are quite tired kan? And then you are looking forward for your weekend tomorrow. Okay, this is the introduction. Okay, in what situation the discussion of damages will be relevant or will come into picture or will come into play. So basically, we are done with all the vitiating factors, okay? And then we discuss about performance, okay? We discuss about frustration, okay? Another methods or way in which a contract could be discharged, okay? It will come to an end, okay? Other than performance or frustration, okay? This is another way to discharge a contract is by way of breach. Okay, of course, we don't want the contract to be breached. Okay, the parties they don't look forward for breach, but it happens. Okay, it happens in many situations. So where one of the contracting parties, or sometimes both actually contributed to the breach. So here, where one contracting party suffer losses, okay, losses here as a result of a breach. So in that position, he or she doesn't matter. Okay, the party will be entitled to an award of damages. So this is the legal entitlement. She can claim for damages. Okay, another word for damages is monetary compensation. But the legal term we use as damages. Remember with S, okay? Because if without S, then usually it is meant to refer to losses, okay, rather than compensation. Okay, now the first question for today, okay? The question is, I will call names after this, okay? There are 2 more people coming in. Okay, I'm admitting all. I think some of you keep on logging in, logging out. Maybe your internet is not so stable. So understood. Okay, the first question for today, because I hope it can be slightly interactive. On what basis, okay, the damages in the contract law are awarded? Okay, basis here, it means what's the aim of awarding monetary compensation as far as contract law is concerned? Anyone would like to try? I have the list of name here. We have Sakina, Adawiyah, Aish, Amar. Who wants to try? Sakina, are you there? Can you respond? What's the aim? Okay, on what purpose? What's the purpose of giving compensation to the one who suffer losses? What's the aim? What's the thing we want to achieve? On what basis? Or anyone can help Sakina?
I want to try, madam.
Emmeline.
Maybe to place the injured party to the position um before the contract is
Before
breached.
ke after?
After.
That's a little tricky kan? Alright, yeah, you are right. Okay. Let us see the answer here. Alright, so for law of contract, so now in your mind, you have to differentiate, okay, with law of torts. Okay, for contract law, okay, damages, compensation, they are, usually we use the term as plural, okay, so damages they are normally awarded, given, okay, on the basis, on the reason to place the injured party, the one who suffer losses, in the same financial position, okay, because for contract law, it's not about physical injury, it's about financial injury, okay, the losses financially. So in the same financial position, as if what? So we assume okay, as if the contract had been properly performed. Okay, remember what's the aim of awarding damages under contract? Under torts law. Shami, are you there? I just mentioned Aish or anyone. In torts law, okay, if we award compensation, what's the assumption? For what reason? For torts law. Okay, contract law, we assume we give you money, okay, as if the contract had been properly performed, okay. But for the 5 people joining, I think you keep on logging in, logging
Me,
out.
madam.
Yeah, Sakina.
to put the injured party to the position before he was injured by
Yeah,
the defendant.
as if he never injured, isn't it? So it's I mean it's different lah. That one before kan, before the things happen. Here, as if the contract had been properly performed. For example, contract of delivery. So we give you money as if the contract had been properly delivered lah. Like that. Okay. So that's the difference between contract law and tort law. I mean both are civil action. So by now you must be able to understand. You must be able to tell the difference. Okay, thank you, Sakina kan just now, right, for responding. Okay, let's move further. All right, this is the copy paste, okay, or cut paste of your statute. Okay, now we are looking at, I mean, last time frustration kan 57 section 1 and section 2. Okay, now we jump. Okay, we go to part 6, 7, part 7. Okay, and the section is section 74, subsection 1. Okay, you can see the title, okay, in capital letter, of the consequences, okay, of breach of contract. Okay, and then another title is compensation for loss or damage, okay, caused by breach of contract. So again, the emphasis here is breach of contract. All right, if you notice, I mean, if you look at on the screen, okay, as you can see on the screen, 1, 2, 3, 4, 5. Okay, there are 6 lines, okay, of the provision, which is quite lengthy. Okay, but the first 4 lines, okay, from the word when a contract has been broken, blah 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 blah. Okay, and then compensation for any loss or damage caused to him thereby. Okay, all right. Until that, okay, that's I mean that's the starting or that's the explanation. But from the word which naturally arose in the usual course of things from the breach. Okay, that's the first limb. Okay, if you remember when we discussed about section 15, caution kan, is also, I mean, we are able to extract 2 limbs. Now also similar. I mean, from the section here, we are able to extract 2 limbs. How do we know? From case law. Okay, so there are 2 limbs. The first one, which, I mean, whatever compensation to be given here, first, there must be something which naturally arose in the past. I mean, it already happened. Okay, it already has been breached. So naturally arose in the usual course of things from the breach. Or, okay, let's say you don't want to apply the first limb. Okay, we go to the second limb. Again, starting from the word which. And you can see the word or. So it's in alternative. You prove either one. Or, okay, which the parties knew. I mean, both parties, both contracting parties, both offerer, offeree knew. So it happened in the past. Okay, knew. When they made the contract, okay, to be likely to result from the breach of it. I mean, they have the necessary knowledge, okay, required knowledge here, that when they sign the contract, they know, okay, if you don't perform, then this is the consequence. They know, okay, what's the what's the possible consequence from the breach. So there are 2 ways or 2 conditions or 2 limbs here. All right, let's move further. Okay, so this is the, I mean, that's how we read lah. Here, the actual provision, okay? And this is the analysis from the provision, okay? So basically, we are able to extract, okay? Take out 2 limbs, okay? Under this section 74, subsection 1, okay? Under which, I mean, it refers to situation in which damages or compensation becomes payable. I mean, the injured party can claim under these 2 limbs, under these 2 situations. First, proof that whatever losses that he suffered, something which naturally arose in the usual course of thing. Usually, this is something which is generally foreseeable to all. I mean, everyone can see, oh, if you don't deliver, then the other party will suffer these losses. Naturally arose. Non-delivery, then there will be somebody, okay, who will suffer losses. But for the second limb, okay, it requires elements of knowledge, okay, from the word knew, which the parties knew, okay, when they made the contract, when they signed the contract. I mean, if you don't perform, then this is the result. I mean, this is the consequence of the breach. But again, it requires elements of knowledge. Okay, the first one, no need to prove you have actual knowledge. I mean, anyone can foresee, can anticipate. You don't do, and then this is naturally arose from the breach. Can see or not? Anyone, are you all okay? Are you following? Okay, there are 2 limbs. We haven't come to the case. So the case will illustrate to us application, okay, of these 2 limbs. All right. So again, if we go back to here, actually the rule here, okay, remember our Contracts Act, it is in pari material to Indian Contracts Law, okay, Indian Contracts Act, okay, Indian Act lah, IA, okay. But then certain rules, okay, actually the origin is from common law, most of the rule actually. So this is example of, okay, here, section 74. It originates, okay, it comes from the rule in this case. So this is, I mean, there are three cases altogether, common law, and this is the first case for today. I mean, you must know all the three cases. Usually they go together, okay? The first case for today, Hadley and Bazendale. If you look at the year, okay, very old case, classic case here, 1854, but this is leading case because from this case we have the rule that we have today. Okay, we have the rule under section 74. So as you can see on the slide, I put it as a title, okay, the leading case on remoteness of damage lah. Okay, something which naturally arose. So this is as you can see the paragraph here, okay, it looks too wordy, but this is actually reproduction of the quotation from Hadley and Bazendale. So if you look closer, okay, actually it resembles the provisions, okay, the wording used in section 74. So this is the judgment, okay, decision in Hadley Bazendale. So now we codify into section 74. Can see, right? But then in the judgment or in the decision by the court here, they also use the word in the contemplation. I mean, in the minds of the parties lah. Okay. I mean, it refers to the elements of knowledge. Then look further. Okay, all right, let's go to the facts. Okay, now we are looking at the leading case, Hadley and Bazendale. I think it's easy to remember the name because it's quite unique, and Hadley and Bazendale. What happened here? It involves certain equipment, okay, certain machinery known as crankshaft. Okay, so it broke. So actually, this is important for to run the certain factory or mill, okay, and then it belonged to a plaintiff, okay, the crankshaft here, and then one day it broke. It cannot function, okay, broke down. And then they only have one crankshaft. Okay, maybe for other mills or other factories, they have more than one. But for plaintiff mill here, they only have one. Okay, it was the only one they had. And without this crankshaft, which is broken now, they could not operate their business. They could not run their mill. So because of that, they enter into contract with the defendant, okay, and defendant is in charge, okay, to repair. So the defendant send the crankshaft to engineers, okay. Now there's a problem, okay, because if no problem, then we don't have the case. So the delivery, okay, I mean for the purpose of repairing and to deliver back to the mill, okay, to the plaintiff mill here, the delivery was delayed. Now it affects plaintiff business because they are waiting for the crankshaft, okay, the repaired one. So delivery was late, and because of that, the plaintiff sued for lost profits. I mean, the more it delayed, the more losses that they have suffered. Okay. Now the issue before the court: can we allow the plaintiff to recover the lost profit? This is something which is financial in nature. I mean, on paper, you calculate, yes, you suffer these losses because of this delayed delivery of your crankshaft. But the court said, no, you cannot recover. Why is that so? Okay, let's go to the reasoning of the decision. Okay, this is just a picture. Okay, if you are wondering how does it look like, okay, this is crankshaft lah. Okay, that's why you have many slides because I put in some pictures like this. Okay, the rule. I mean, from the Hadley and Bazendale case just now, okay, from this case. So, this is the finding by the court observation. Okay, the court found that an aggrieved buyer, I mean, the one who suffer losses, okay, aggrieved buyer of services will be unable to recover, okay, consequential losses. So, whatever losses, as far as the case was concerned, was regarded as consequential, okay, resulting from the breach, unless the losses are, I mean, this is the condition. You can claim for these losses, okay, as consequence of the breach, provided it fulfill these two requirements, either one. Okay, the first one. First, it has to be something which is natural consequence of breach. I mean, without this crankshaft, will your business be affected? But actually for other factories, they have more than one, okay? So maybe that it's not natural for you to have one, or you have to make it clear to the other party. And then another condition, another situation in which you can claim, the buyer, in this situation, the plaintiff, okay, brings the circumstances, okay, whatever difficulty they are having, which would generate the losses expressly to the seller's attention. For the case of Hadley and Bazendale, these two things are missing. Actually, that's why they cannot claim, okay? It sounds not fair, kan? But then that's the rule. So they must satisfy, they must fulfill the rule, then only, fulfill the condition, then only they can claim, Alright, so this is the reasoning by the court. Okay, the court reasoned that defendant, okay, the one who is in charge of repairing, okay, had no way of knowing that plaintiff would lose profit, okay, if the shipment of the shaft was delayed. Because why? This information was not communicated directly. I mean, they're just focusing on repairing, but they don't know whatever profit whatsoever here, okay, to them, and therefore the loss of profit was not reasonably contemplated by both the parties when they made the contract. I mean, this is not really communicated, so no knowledge, and then it's not something which naturally arose, because for other mills they have more than one shaft, okay, but for plaintiff mill it wasn't communicated clearly, so because of that cannot claim for damages for breach of contract. Was there breach? Yes, there was breach. The delay is the breach. Okay. All right, let's compare with another case. All right, again, a still explanation just now. Although the fact that the mill was closed was communicated, so the defendants was aware, yes, the mill was closed, but they don't know that it was closed because of this, the only broken crankshaft, okay, and could not reopen again until it was fixed. I mean, lacks of communication or lacks of necessary information here. All right, and this is the summary. Okay, I mean, what do we learn here? So indirect or consequential damages are only recoverable if reasonably foreseeable and also arising naturally. So here it's not really foreseeable, especially to the defendant. They cannot foresee, okay, that the delay on their part will cause losses, okay, to plaintiff business, okay. And that's the if situation. Okay, most of you like the if situation, kan? So here, if the plaintiff, okay, if the mill owner had made it clear, okay, that the mill's operation was dependent upon getting the new crankshaft, or get it repaired, okay, the outcome, the decision would have been in their favor. For example, we change a little bit of the facts. For example, when the plaintiff sent the shaft for repairing, okay, and they really made it clear to defendant, oh, you make sure that you send on time. I'm really depending on this one, for example, okay, then yes, can claim, okay, because everything is so clear. But for this case, I mean, no, not enough information, not enough communication between the parties. So defendant cannot be made to pay compensation, okay, for whatever losses suffered by the plaintiff. I mean, that's the rule, basically, to do justice to both parties here. Okay, let's move to another case. We have three cases. I mean, it's like, it's not twin, trio, okay, cases, they go together. All right. Here, we have another case. This is court of appeal decision. Okay. The principle laid in Hadley Bezendale was restated. I mean, it was being applied in court of appeal decision. Later case, the case name is Victoria Laundry, okay, Windsor Limited, and Newman Industries Limited, 1949. But when you write in your exams later, you can just put as Victoria Laundry. So I know you are referring to this case. Not only Victoria, okay, Victoria Laundry, at least 2 words lah, right? What happened in Victoria Laundry? Okay, just now it's about crankshaft. Now it's about boilers. And we have another term, dyers. Okay, here. Again, it's about late delivery. Just now also is late delivery. Okay, it's not non-delivery, it's late delivery. Deliver, but a little bit late. Or maybe not little, but maybe very, very late. Okay, here, there was a late delivery of a boiler to dyer. So plaintiff was the dyer. The dyeing, it's not dyeing mati. Here, dye coloring, okay, coloring of certain things lah, coloring of clothes, for example. So the dyers, the plaintiff here, they claim for two things, okay? I mean, similar to Hadley Bezendale. First, they claim, not similar, it's slightly different. Okay, here, first they claim loss of profit arising in the ordinary course of business. I mean, you delay the delivery of this boiler, then we suffer losses. And they also claiming for another type of compensation. Damages here, the second one, they are also claiming for loss of exceptional profits, okay, on especially advantageous government contract, meaning that here they are, maybe they are bidding, or they need to fulfill I mean, whatever contract they have with government, with government. So because of this late delivery of boiler, so it affects their whatever contract with the government here. So there are two headings, okay, or two types of the compensation that they ask from the defendant who delivered the boiler very, very late lah, delayed, okay. All right, and then when the case went up to Court of Appeal here, the court has to ascertain, should we allow both claim? Okay, or which claim can be allowed, can be recovered? Okay, we have another picture. Okay, you can compare just now, kan? I show you picture of crankshaft. It's like not so, in terms of size, not so big lah. That's why maybe defendant cannot really think, oh, without that small thing, you cannot operate your business. But for boiler, I mean, without boiler, definitely no one can do business. You can see how big the thing is lah. Boiler. I mean, you want to boil whatever things here on the inside. So that's the picture lah, the illustration. Okay. I mean, there must be boiler for the plaintiff in order to proceed with their business. He doesn't want to move. Okay. All right. Again, I mean, this is the rule that we extract from Hadley-Bazendale, and it was being applied in this particular case, Victoria Laundry. Okay, so the court said clearly, okay, when there is a breach of contract, so the breaching party. So we have the word like the breaching party, the one who breached the contract. We also have the word contract breaker, the one who break the contract. Okay, so the breaching party should be liable to pay compensation, okay, for damages that naturally arise, okay, or damages that both of the parties contemplated, have knowledge, okay, at the time they made the contract. Is it fulfilled or not for this Victoria Laundry case? All right. So here, remember, okay, they were claiming for two types of losses. The court said, well, the ordinary losses of, I mean, refers to profit fell. I mean, it falls under the first heading, the first type. I mean, yes, this is something which naturally arose. Without boiler, late delivery, it will affect the business, it will affect the profit. But for the second type of damages that the plaintiff was claiming, okay, exceptional profit on government contract here, it falls under the second one. So there's no elements of knowledge and not within contemplation. Because why? They never inform, okay, about this government contract. Usually you don't want people to know kan about whatever contract that you have. So here, lacks of knowledge, that's why cannot claim. Let's say we twist a bit. For example, plaintiff made it clear, oh, please send or please deliver on time because I need to fulfill my contract with government, for example. Then in that situation, can claim for both. But for this case, Victoria Laundry, there's no knowledge, no information being communicated from a plaintiff towards the defendant. Okay, but they were trying to claim, but the court didn't allow. Okay, no knowledge that the boiler was required to fulfill unusually profitable contracts unless it was made clear from the very beginning. Then it sounds fair, isn't it? So you can claim for the first one. I mean, without boiler, it will affect your business. Late delivery, it will affect your business. But for the second one, I mean, no one has the idea that you are actually fulfilling contract with third party or with government here. So, I mean, the moment you suffer loss, so you cannot claim because you didn't tell, okay, the other party from the very beginning. All right, that's how the court apply or reinstate, okay, the rule, okay, extracted from the case of Hadley. Okay, first we have like Hadley-Bazendale. Now we have Victoria Laundry. Okay. All right. So again, I mean, that's why we have many slides kan. I put in case analysis lah. I mean, it explain more, okay? I mean, why the court came to such a conclusion, okay? Especially the second one, all right? The engineering company, I mean, the one who's supposed to deliver the boiler, okay, cannot plead ignorance as to what the boiler, I'm sorry, this is about the first claim. I mean, there's something which naturally arose. Engineering company cannot plead ignorance as to what the boiler was because any reasonable person will understand that it is essential to this dying business. I mean, there must be boiler. Late delivery will affect business. But if you compare with Hadley-Bazendale, that one, I mean, it's not really, I mean, it's not the same, okay, for this particular facts. I mean, crankshaft maybe one mill would have more than one, but for that, Hadley-Bazendale, only one. And it wasn't made clear to the defendant, so cannot claim. All right. So we have the first two cases just now, okay, Hadley-Bazendale and then Victoria Laundry. Now we have the third one. They all go together, okay. The above case was discussed by House of Law. Just now, a Court of Appeal, okay, in Victoria Laundry. Now, House of Law, okay, in another case, the later case, the case name is the Heron 2. Heron, I think, refers to the name of a vessel or a ship, okay, 1967. What happened here? This is very simple facts, okay. Just now, first is about crankshaft. Okay, second is about boiler. Okay, daya. Now it's about sugar. Okay, everybody love sugar kan? As sweet as sugar. Okay, bersemut. Alright, so here, plaintiff, they have a contract. I mean, they enter into a contract, okay, with the defendant. So what's the task here? To deliver, okay, sugar to Basra. So Basra in Iraq lah. Alright. And then again, there was late delivery. I mean, most of the time for breach of contract, example that we are discussing today is about late. So you never be late lah. Okay, late will entail certain consequence kan. Alright. So here, defendant who's supposed to deliver sugar, okay, was late. And in the meantime, another vessel with the same commodity sugar arrived in Basra. So now it caused the market price to drop. Okay, because if the ship or the vessel arrive early, then the market is still high. But because of the certain days late delivery here, not sure the exact period, but there was late delivery, so it affects the market price of sugar. Okay, our Zoom will end in 10 minutes. Okay, hopefully we can finish the case. Okay, I don't want to have more than 40 minutes class today. Okay, because it's just starting of the topic. Okay, and then now plaintiff was not happy because now he suffered losses, okay, because of the late delivery of sugar. Okay, plaintiff sued, okay, the defendant for the difference between the amount that would have been received if the contract had been performed and the amount that plaintiff actually got. I mean, because late delivery, I have to sell off the sugar at lower price. So now claiming for the difference of the price. For example, if you arrive early, then I can sell for 100K. But because you arrive so late, I can only sell for 50K. So now asking for compensation for the 50K. Okay, 50K affected price. That is only example, illustration. Okay, whatever calculation. But I mean, the plaintiff suffer losses. Okay, now the issue before the court, okay, before House of Lords, shall the plaintiff receive the requested damages? Okay, the difference of price here, and we need to look at the rule. Okay, we apply the rule. If the loss is foreseeable, okay, is it something naturally arose here? Then it may be compensated. Then you can ask for the compensation. All right, and then in incoming or in making its observation, okay, House of Lords discuss about how serious the risk of loss, okay, must appear, okay, when they sign into contract. So and then how serious the risk, and then is it foreseeable, okay, and then as far as the contract was concerned, the defendant, the ship owner, must be presumed. So we infer, you are presumed, okay, to know the price in commodity market fluctuate, okay, certain subject matter, okay, certain commodities, certain assets, the price fluctuates so much. Okay, for example, sugar or even gold, okay, certain things, it fluctuates so much here, okay, and delay, okay, in the usual course of things, okay, something which natural, okay, will cause certain losses as a natural and probable result of the breach. So yes, appellant here can claim and was liable under the first limb. This is something which naturally arose. But again, it depends on the subject matter. Here is about sugar. So sugar, the price fluctuates lah. It goes up and down, up and down. Certain things, I mean, the price is pretty stable or it's quite fixed. Not easily up and down. Okay, but for sugar, delay for few days, for few weeks, okay, it will affect the price badly lah. Okay, here. Okay, coming back to the section, a provision that we have read together just now, okay, the actual wording is which naturally arose in the usual course of things from the breach. Okay, what's the real interpretation of these words here? Phrases lah, many words here, okay. Keyword is naturally arose, but actually it refers to imputed knowledge, okay, how does it work? Contract breaker, or the one who breached the contract, is assumed to have knowledge of losses, okay, which is to result, which is to happen from a breach of contract in the ordinary course lah. So a good example just now, like the case of Heron 2 just now, knowledge that prices in a commodity market fluctuate, and whatever delay in the usual course of thing will cause certain losses as a natural and probable result of the breach. So good example is delay, okay, and it relates to commodity. Because why? The price fluctuates lah, goes up and down. Okay, if you read your statute later, okay, you can see that there is a long list of illustrations. So here we have illustration A until H, giving us example, okay, in which whether what can be claimed and what cannot claim. Usually, if physical class, I will ask students lah to read illustration A and then explain, illustration B and explain, illustration C and explain. But for today, now remaining time as from by Zoom now, we have 5 minutes left. Okay, maybe I choose one and I read to you lah. Okay, and then It's interesting actually. For example, A, we have a new term that we might not be familiar with. Okay, here, for example, here A and B lah refers to party. A contracts to sell and deliver 50. Okay, they use the measurement of gantangs or gangtangs. Okay, of okay, another word that we might not use. I mean, we don't use every day. Salt, yes, but then now salt. How do you pronounce that? Alia, how do you pronounce that? Because your name appear here. Aish, are you there? How do you pronounce that? Fatul, are you there? How do you pronounce that? 50 gantangs of what? Salt? Is it saltpeter? Anyone? I'm talking to my computer or I'm nak cakap talking to the wall. It's not in the class. Okay.
Macam salt,
Yes,
salt
madam.
How do you pronounce the word? 50
Peter.
gantangs.
Peter.
Petre?
Saltpeter.
Peter, Petre. We don't use the word common kan? Alright, but it's about certain things lah here. Okay, thank you for at least you are there. Okay, you are responding to my question because sometimes the challenge of having online class, whenever lecturer or instructor ask question, nobody respond. As if you are there online, I mean virtually, but we ask you to respond, you don't respond. So we don't know whether you are actually there or not can. Alright, so here, so at a certain price to be paid on delivery, I mean they will pay during delivery, and then there's a breach of contract. A breaks his promise, and for this particular illustration, okay, B is entitled to receive from A. A is the one who break the promise, okay, by way of compensation, the sum, okay, if any, by which the contract price falls short of the price for which B might have obtained, okay, 50 gantangs of salt petre here of, I don't know how to pronounce it, I didn't check, okay, of like quality at the time when the salt, okay, ought to have been delivered. I mean, whatever losses, okay, whatever the difference or gap of the price, so can claim. Okay, my question, okay, please respond. What if, okay, there was late delivery, but you were so lucky, I mean, the price, you receive more profit because of the late delivery. So can you claim for compensation despite that there was breach because late delivery, but you receive more in terms of profit? Can you claim?
Macam no itu sebab ada benefit.
Adli, can claim or not?
Tak boleh.
Tak boleh because no losses kan. Okay, yeah, there was a breach. Thank you, Adli. There was breach of contract, but you don't suffer losses, so cannot claim. Okay, because it's only meant to cover for your losses. Okay, but now you get more profit. So actually nothing can be done lah, despite there was a breach of contract here. Okay, for illustration B and C, you can read on your own. Okay, we have 2 minutes left. Let's see what do I have after this. We also have D, E, F, okay, for your reading purpose, or maybe we can do the reading together when we have physical class. Okay, this is a long case, so we have to stop now. For this slide, I mean for this case alone, because it covers both limbs actually, so we are going to discuss thoroughly. So we have few slides. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13 slides, okay, for the case of Datuk Muhammad Anwar bin Embong. Okay, so we reserve this case for our physical class next week on Tuesday. All right, with that, so let me stop share. So we adjourn our class today, and then let me just stop record.